Well, thank you everyone for joining us for another episode of the Reinhart Labor and Employment Minute. I'm Rob Driscoll. I'm with Reinhart's Labor and Employment Department. And today I'm pleased to be joined by Michael Gentry, who is also a member of our Labor and Employment Department. But Michael is also a member of Reinhart's Data Privacy and Security Practice Group. So thanks for being with us today, Michael.
Hi, Rob. Thanks for having me.
Absolutely. We're glad to have you here and glad to maybe speak about a topic that's a little bit different from our normal topic list for this presentation. It may not be immediately apparent to everyone how data privacy and labor and employment cross with one another. So could you just explain how the two areas interact and what human resources personnel should know about data privacy?
Absolutely. Thanks again, Rob. The truth is that adopting good data privacy and security measures is important to any operation that has and maintains electronic data and information about its customers, vendors, and yes, about its employees. So several states have recently expanded their data security requirements, and many now require some level of reasonable security measures to protect their data, notably not Wisconsin yet. But regardless of the state, a company's workforce is either its best defense or its weakest link in its plan to prevent, for example, hackers from getting into company systems and stealing data, which could result in embarrassing and costly required notices under Wisconsin's data breach law or other state equivalents. It could potentially be even more costly in states that have broader protections like California or Colorado, which recently expanded its data privacy law. So one thing we stress is regular training of employees to help them be on the lookout for suspicious emails and other electronic communications that are actually hiding malware with which a hacker can break into an employer's system. And another place where they interact is in making sure that employees only have access to the data that they really need to perform their jobs. And part of that, as you might imagine, is IT infrastructure, but also part of it is using things like employee policies and even contracts to make it clear that employees are authorized to access some information, but some information is off limits, and that there are potential consequences if they cross that line. So there are several interactions, and I think it's expanding, every day.
I think both of us have, practiced in the areas of employment litigation. And one of the kind of recurring topics that comes up is, an employee who's being terminated, always a difficult situation for any employer. And a lot of times as they're walking out the door, before they walk out the door, they're accessing data, private data, confidential information, and taking it with them. It's, of course, very tempting if they know they're leaving or if they're being let go, to try and grab information before their employment actually ends. So what are some steps that employers can take to prevent this from happening, to kind of protect confidential information and the privacy of the data that they do maintain?
Yeah, I'm glad you asked, and it is a big deal, and especially with non-competes becoming less and less favorable, that is becoming a bigger issue for a lot of employers. And I would say, first off, when separating an employee, an employer is hopefully able to lean on those strong agreements and strong employee policies in order to require the return of not just physical property at the end of employment, like computers, but also make sure that those documents cover the data that the employees have access to and use during their employment. And along with that, a lot of times we encourage companies to ask their employees to cooperate to remove any sensitive, personal, commercial, or competitive information off of even personal devices. So all that depends on having strong policies and potentially agreements that require employees to do that at the end of employment. And this is especially true for more senior level employees or employees who have access to proprietary data, for example, sales or revenue generating employees who very well may use curated customer lists that the employer takes time to develop and have access to trade secrets. In those circumstances, or even in other circumstances, we advise that employers conduct some type of review or audit of the employees' email systems and computers and devices they use during their employment to make sure that company information is not slipping through the cracks or the employee isn't taking it with them on the way out the door. This may be less necessary when employers are able to keep their data an information workflow under virtual lock and key, like for examples where employees are only ever using virtual private networks for the information flow, and they aren't even able to access personal email or folders. And also, since we're talking about separations, it's also appropriate to address some of these issues through separation agreements when the employer thinks that it's appropriate. So there are ways to handle it, but absolutely, it's an expanding issue employers should be aware of.
You mentioned non-competes, becoming, say, less favorable, and certainly there have been some states that have passed statutes in recent months, recent years that really tighten up the restrictions on non-competes. Illinois comes to mind, Massachusetts comes to mind, but it makes me wonder: are there other things on the horizon involving data privacy or affecting data privacy that employers really should be watching for, say, in the coming months, and should be maybe taking steps to prepare for already?
Certainly. I would say one thing is, because of the holidays, winter, and honestly, the ongoing pandemic, many employers are likely to receive an increasing number of requests to continue working remotely from their employees, for whom that's something that they can do. And with remote work, good data security hygiene is really critical. State laws, customer and vendor contracts that place certain security measures on how employers store, process, and maintain the data that is critical to those relationships. Those laws and those contracts don't generally have any exceptions for when employees are working remotely. So it's still critical to make sure that those connections with the employees' computers, networks, and virtual private networks are very secure. Another issue that I would raise is that the Federal Trade Commission is expanding its oversight of companies' data security practices, at least for companies that receive federal funding. The agency has made clear that it welcomes complaints from whistleblowers for employers that represent to the government that they are taking certain data security measures in order to get government contracts, but then aren't actually taking those measures going forward. And lastly, I would add that because of a recent Supreme Court decision, employers are now less able to use the Federal Computer Fraud and Abuse Act to seek remedies when an employee steals company confidential data and uses it, for example, for a competitor. And this makes it more important than ever that employers specify what data employees are able to access and have authorized access to use during their employment. And again, draw that line to say, this is okay for you to use during your employment, and this is beyond your authorized access. So,
yeah, I guess so. If I were to sum up what the concerns are, then the idea is your employees, don't forget about your employees when you're protecting data privacy. Not only that, to protect from them from doing something with your data and your confidential information, but to make sure that they have the training and you have the documentations in place with them to make sure that the data is protected. So Michael, this is great. Thank you very much for joining us today.
absolutely. Thanks again for having me, Rob.
And this has been the Reinhart Labor and Employment Minute. Thank you to our audience for watching. We'll see you next time.